All right, let's get into tort law. I try to give y'all time to talk about other things, distract us from the business at hand, but y'all seem to want to get right into it, so we will. All right, so up to this point, we have been talking kind of about the law in general terms, sources of law, the court systems, how they're set up, that kind of thing. For the rest of the semester, we're going to take one unit at a time, a different area of the law. It'll be kind of high-level overview type stuff because, for example, like we're going to spend 3 class periods on tort law. That is something that a law student would spend an entire year studying. So we'll hit tort law. We're going to get into, not this unit, but future units, we'll get into criminal law, we'll get into employment law, we'll get into intellectual property law. So from here on out, we're basically going to take a week at a time, just a different area. So tort law, what is tort law? That might be a word that is unusual or unfamiliar to you. It certainly was unfamiliar to me when I went to law school. I'd never heard of tort law before, and I'd never really heard of what a tort was. A tort is basically a wrongful act. It's the most basic definition I can give you of a tort law. I want to give you some context of torts and how they relate to criminal law for a second. So remember how I told you earlier in the semester that we were going to divide the law into criminal law and civil law, and that civil law was basically everything that's not criminal law. And that remains true. Tort law falls under civil law. It is not in the same category as criminal law, but there is some overlap. So some of the things that could create criminal responsibility can also create civil liability under tort law. Here's an example. O.J. Simpson. Y'all are familiar with O.J.? That was before your time, but not before my time. So O.J. allegedly killed his ex-wife, Nicole, and the state of California brought criminal charges against O.J. for murder. Y'all are familiar with that? Nicole's family sued O.J. as well. But a private citizen can't sue another person for a crime. That's the responsibility of the government. So her family sued him under tort law, which is civil. And the tort that they chose to sue him under was wrongful death. So tort law exists to give private citizens a way to recover from other private citizens for wrongs that are done to them in civil law. Why would that be necessary? Well, there are the interest of the government in prosecuting crimes is to keep the peace, to promote a lawful society, to punish people for wrongdoing, to deter others from doing wrong things. In tort law, though, the main goal of tort law is to give the person who's been wronged a way to recover for their losses. The government's interest is more punishment and keeping an orderly society. The private citizen interest is getting paid, compensated for their losses. So in the O.J. case, the state of California brought the criminal charges of murder to punish O.J., to show citizens that you can't go around killing other people, although he did, got away with it. But Nicole's family brought their case to recover for the value of her life that he took. So 2 different motivations, 2 different courts cases, 2 different areas of the law, but the same act. Incidentally, we may have already talked about this. O.J. was found not guilty of the murder, but he was found liable for wrongful death in the civil case. Did we talk about this already? How could that be? How could he be found not guilty in the criminal case, but liable for wrongful death? What explains that? Ryan.
May have been a difference of intent.
A difference of intent. There's certainly two different things, right? The crime of murder is not the exact same as the tort of wrongful death. They're similar. But in a criminal, what's different between a criminal case and a civil case as it relates to what the jury has to decide? Jail time. The consequences are different. But remember, the standard of proof is different in a criminal case than in a civil case. In a criminal case, the standard of proof is beyond a reasonable doubt. So that jury had to find that O.J. was guilty of murder beyond a reasonable doubt, and they decided that he wasn't. But in the civil case, that jury only had to decide whether O.J. was liable for wrongful death by a preponderance of the evidence, more likely than not, 51% to 49%. So two different juries, two different standards of proof. Same act, same evidence, but a criminal jury decided that he was not guilty of murder, and the civil jury decided he was liable for the tort of wrongful death. That could be explained by different burdens of proof. The burden of proof in the civil case for the tort was much lower than in the criminal case. Private citizens also, well, I mentioned already that they have different motivations. In criminal cases, sometimes they will make the defendant pay restitution. In other words, pay for the damage they've done to the property of the plaintiff, or of the victim. But in a criminal case, the victim is not going to recover for some things like pain and suffering, loss of limb, loss of companionship, and all of those are available in tort law as damages. So the potential for money recovery is much greater in a tort case than it is in a criminal case. That's another explanation for why we have the two. The damages that are available in tort law, in civil cases, are both compensatory and punitive. Compensatory damages are just what they sound like. They compensate the victim or the plaintiff for their loss. We can split compensatory damages up into general damages and special damages. The difference in that is that special damages are things that we can quantify easily. My medical bills. I can bring you literally, present the jury with a copy of my bill. This is what it cost me to have the surgery. My car was damaged. This is what the repair shop quoted me or charged me to repair my car. I missed work for 3 days. I make this much money, so 3 days worth of work was this much that I missed in pay. Those are special damages that we can quantify. General damages, they're also to compensate me, but they're a little bit harder to quantify. For example, pain and suffering. The pain and suffering that Nicole's family incurred, there's not a formula that we can go to and break out a calculator and plug in what pain and suffering is. If I lost my arm in an automobile accident, I want compensatory damages for that. But there's nothing that can show that I can't present to the jury a bill for my arm, for the loss of my use of my arm. I could present a bill for the medical costs for sure. If I'm a professor or a lawyer, I can still do both of those jobs without my right arm. So the value of my right arm might be very different than the value of the arm of Samir or Camilo, who are tennis players. Maybe they're going pro. Maybe they're professional, and they rely on that arm to make a living. So if they lose an arm, their case, they may be asking for more money in compensatory damages than I would be, because I can still do my job without it, whereas they might not. So compensatory damages compensate the plaintiff for the loss that they've incurred. Punitive damages punish the defendant for the conduct. They're a lot less common than compensatory damages. Okay, punitive damages, that's where the big money is. Like when you see these jury verdicts that are just millions of dollars, a lot of times it's to punish the defendant for what they did. Usually the conduct has to be outrageous, egregious, intentional. The jury is sending a message, maybe to a good example of punitive damages would be in the McDonald's coffee case that we're going to talk about next week. That's a great example, actually. So that was not a criminal case. McDonald's didn't commit a crime, but the lady who spilled the hot coffee in her lap sued McDonald's under tort law for the damages that she had incurred. And she presented medical bills, things like that, for her compensatory damages. But she asked for punitive damages to punish McDonald's. And in support of that, at trial, she was able to show that McDonald's knew that they were serving coffee that was too hot and didn't care about it. So in addition to the compensatory damages she got to repay her for her medical bills, they dinged McDonald's for a couple $1 million in punitive damages as punishment. So if you're going to sue somebody in tort, it'd be great if you had some punitive damages to ask for. That's where you might can get super rich. All right, that's the idea of damages. So today I want to spend the rest of class talking about intentional torts. There are unintentional torts. That's what we're going to talk about on Thursday. That's the tort of mostly the tort of negligence. That's where I cause harm to somebody accidentally, being careless. I'm driving down University Avenue. I'm looking at my phone. I'm not paying attention to where I'm going. I don't see Kelsey's car stopped at the red light in front of me. I rear end her. I did not do that on purpose. But I'm still responsible for the damage to her car. It was my fault. If she's going to sue me in tort, she's more likely to sue me for the unintentional tort of negligence. Today we're talking about intentional torts. So a required element of every tort that we pick today, or that we talk about today, is going to be that I intended for my actions. If I walk up to Xavier and punch him in the face, I meant to hit him in the face. He could sue me for the intentional tort, which we're going to talk about in a minute. So just because intent is required today does not mean that accidental harm people aren't responsible for. They are. It's just a different tort. So when somebody has been harmed and they want to sue under tort law, it's not as general as just going to court and saying, he hurt me and I need to be paid for it. You actually have to pick a specific tort to sue the person for. And there are plenty of them. They're defined by state law. It's like a menu, kind of. You've been harmed or wronged by somebody else, you can go to the menu of all the different torts out there and you can sue them for all the ones that you think you can prove. So let's talk about some intentional ones today. First one I want you to be familiar with is assault. Assault happened. Now, we tend to think of assault as beating the hell out of somebody or getting the hell beat out of us, right? That's our street understanding of assault. But the legal definition of assault is actually a little different than that. The legal definition of assault is an intentional, unexcused threat of immediate, harmful, or offensive contact that creates in another person a reasonable apprehension or fear of harmful contact. So if we go to court and you sue me for the tort of assault, let's get a better example. Gio, I walk up to you after class and punch you in the face. All right? Law enforcement might be interested in that. Assault is a crime. Okay, it is. But it's also a tort. So whether or not law enforcement decides to arrest me and charge me with a crime, you still have the right to sue me under civil law for the tort of assault if you want to. And why might you want to do that in addition to whatever law enforcement may or may not want to do? You might have some damages that you need to be compensated for that law enforcement is not going to be concerned about in their criminal case. They might arrest me for assault, charge me with it, convict me for it, but that doesn't necessarily pay your medical bills or your pain and suffering or your other damages. Okay? So your interest is, in the tort case, is suing me to recover for whatever loss or damage you've incurred. When we sue somebody in tort, we're going to take the tort that we choose and we're going to use the state's definition of that tort. And at trial, we would have to prove every element of that tort. So for assault, Gio sues me for assault. I punched him in the face. He's got to prove that it was intentional. Probably got a good case on that, right? I mean, I walked up to him, cocked my fist, and took a swing. There's not much I can argue about that not being intentional. He's got to prove that it was unexcused. I didn't have any reason to do it. It was a threat of immediate, harmful, or offensive contact. And that his apprehension of being harmed was reasonable. If he can prove those things to the jury, then he can recover for the tort of assault. Notice in assault, nothing in the definition says that I actually hit him in the face. It was creating a reasonable fear of being harmed. That constitutes assault. So when I walk up to Gio and cock my fist and swing at him, whether I hit him or not doesn't matter. I've committed the tort of assault if I created a reasonable apprehension of fear in him of being hurt. I pull a gun on Gio in class. well, I'll pull a gun in class, I've probably committed assault on every student in here if I've created a reasonable fear of being harmed. These days, that'd be pretty reasonable. So every student in here could sue me for the tort of assault. I didn't hit anybody. I didn't pull the trigger. I didn't shoot anybody. But I've still met the definition of assault if I intentionally created a fear of harm, of being harmed in you. What if I pulled an Orbeez gun? Everybody know what an Orbeez gun is? If I pull an Orbeez gun on y'all, you going to sue me for assault, Alan? You don't know what an Orbeez gun is? It's like a toy gun. It shoots those little gel things. A what gun? Splat gun. There you go. I pull a splat gun. I'm standing up here, I pull a splat gun. And you sue me for assault. Okay? You've got to prove in court that, let's go through it, was intentional, was unexcused, it was a threat of immediate harmful or offensive contact. I might say, it's not harm. I can't harm him with a splat gun. You also got to prove that it created a reasonable apprehension of fear. Is it reasonable that he was fearful of being harmed by a toy gun? My argument would be no. He could make that argument that he was. But let's say that Alan sits in the top corner of the room and I walk in through here with an Orbeez gun and the lights aren't on yet, and all he sees is the outline of a gun. The fact that it was a toy gun might not matter as long as it was reasonable for him to be scared that he was going to get shot. I tell y'all this is an Orbeez gun. Everybody knows what it is. I show it to Alan. Maybe not reasonable that he's scared of it. But he's back there and he sees me come in a dark room with a gun, a toy gun. Pretty reasonable that he's not going to have to be worried about whether or not it's a toy gun or not. Sue me, right? So reasonable apprehension of fear is one of the elements in assault. If I walk up behind Alan with a crowbar and he doesn't see me coming, and I clock him on the back of the head with the crowbar and knock him out, and he sues me for assault, y'all be my lawyer. What is our defense? What's my defense? Say that again, Kim. It was intentional. Well, you're my lawyer. You're my lawyer. He sued me for the tort of assault. We can read the definition. There's a hole in his case based on the definition. What is it? He was never in any reasonable fear of being harmed. He didn't see it coming. I don't meet the definition for assault in that case. Now, does that mean I get away with it? No, because why? He can choose another tort. He can choose the next tort in our list, which is battery. Battery is an unexcused and harmful or offensive physical contact intentionally performed. So he might not can sue me for assault, but he could dang sure sue me for battery. What about in the case where I walked up to Gio and punched him in the face? Probably assault and battery, since he saw it coming. So in tort law, the lawyer will take whatever the facts of the case are, and they'll try to see how many different torts those facts would support. If you're going to go to court and sue somebody, you might as well include everything that you think you might be able to prove, increase your chances of recovery. So assault and battery, they go together very often, but not always. I walk up behind Alan. I didn't assault him, but I committed battery. What about, Kim, if I'm walking down the hall and somebody jumps out from behind the wall with a gun and scares me, and my reaction is to throw up my elbows and stop, and when I do that, I slam my elbow into Jevin's face and I break his nose. He sues me for battery. You're my lawyer. What's our defense this time? It's the same defense you gave me the first time. It wasn't intentional. Now, does that mean that if I break Jevin's nose that there's nothing he can do about it? No, it just means that he can't use an intentional tort. He might have to find an unintentional tort or negligence or some other way to recover from me. Doesn't mean I'm not responsible. It just means he can't use an intentional tort. Torts are going to have a definition, and the facts of the case will have to meet all the elements of that definition in order for the person to be liable for the tort. All right, so we've talked assault, we've talked battery. Let's talk false imprisonment. False imprisonment comes up a good amount in the commercial context with shoplifters and people who have been restrained against their will. The definition you'll see is intentional confinement or restraint of another person without justification. That'd be the elements that we'd have to meet for false imprisonment. Note that false imprisonment does not necessarily require physical restraint. If I chain Mr. McRae to his chair for the rest of the day, I pretty much have met the definition of false imprisonment. He can't go anywhere. But if I tell you, Tristan, don't get up out of that chair when class is over because I've got a gun in my pocket, and if you get up, I will shoot you. And I stand right here the rest of the day and stare at him. He can't get up. I mean, he could get up, but he doesn't. He sues me for false imprisonment. He's probably met the definition. Did I intentionally confine him to that chair? I sure did. I didn't do it physically. I didn't tape his arms. I didn't zip tie him. I didn't hold a gun to his head. But the threat of being harmed kept him restrained. So that would count as false imprisonment, just like it would if I had duct taped him to the chair. Like I said, it happens a lot in the commercial context. That's why you see in there that one of the elements is it has to be without justification. So maybe Tristan admitted that he killed somebody on the way to class this morning. And I'm like, hey, let's hold him down and tie him up to that chair till the policeman can get here. All right, and we do that. And he sues us for false imprisonment. My defense at trial is going to be what? That I was justified. That's right. I had a good reason for doing it. And of course, we know that all my examples are not serious. All right. Intentional infliction of emotional distress. Anybody heard about this before? Intentional infliction of emotional distress. That tort means that what you did to me was so outrageous, so egregious, so bad that I suffered emotional distress because of it. And I need to be compensated for that. I call it a throw-in tort. Usually you don't see it as a standalone. I mean, usually you see it as it goes along with something else that somebody did. So they've committed another tort, but they also caused emotional distress. So we're going to throw in or add on that tort. Yes, ma'am. Yeah. Let's say that I told Tristan not to get up out of that chair or I was going to shoot him. And we stayed there the rest of the day. That would cause, if I were in his shoes, that would cause me some emotional distress. Be worried that I might die. So if he sues me for false imprisonment, if I'm his lawyer, I'm dang sure throwing in intentional infliction of emotional distress. Gives me another way to recover against the person who committed the tort. That's a great observation. A lot of states require that there be some physical manifestation of emotional distress. In other words, it's not enough just to say that you were emotionally distressed. You've got to show how it actually manifested itself in something like I had a nervous breakdown. I had to go to the hospital when this ordeal was over and be treated for anxiety. I had PTSD as a result. And the evidence for that is that I had nightmares, had to be medicated. Some evidence that I can point to show what my emotional distress was. Again, most of the time it's outrageous, just egregious conduct. If I walk up to Alan and take a swing at him and miss, and he sues me for the tort of assault, but he also includes intentional infliction of emotional distress, that's going to be harder to prove. I mean, yeah, you were scared for a second. Were you really scared of me? Look at Tebow. What's he going to do to you? He didn't hit you. If you were scared, it was for a nanosecond. What's your evidence of emotional distress? So a little bit harder to prove. Outrageous, egregious type stuff. If I don't want to use that example. Let's move on to defamation. Defamation is an intentional tort that damages someone's reputation. Again, this is a great example of why we might need tort law in addition to criminal law. If I say something false about somebody in here that damages their reputation, is law enforcement going to be interested in that? Probably not. They've got other things to do. But the person that I trash talked dang sure has an interest in either recovering for the damage that I did or making me stop saying whatever it is I'm saying that's false about them. I think that defamation has always been around, but it gets a lot of press these days. There are a lot of people suing other people for defamation. All right, so the elements of defamation are a false statement of fact. The statement has to be about the plaintiff, and it has to be harmful to their reputation. And it has to be published to somebody other than the person who's being defamed. Defamation can take two forms, and I'd want you to know the difference. Spoken defamation is slander. Written defamation is libel. Libel. That is not the same word that I've been using this morning as the basis for liability. I'm liable for a tort, L-I-A-B-L-E. That means I'm responsible. Not the same, the two different words here. I say them the same, pronounce the same. Libel, the tort of defamation, is when you write in a text or a book or a magazine article or a letter or a note or put on a sign, written defamation. All right, let's say then, Mr. Moss, that you own Guthrie's, the Guthrie's on Macon Road. And I tell y'all this morning that I eat a Guthrie's a lot, and I have just discovered that they serve cat meat and call it chicken fingers. I'd say that to the class this morning. You own Guthrie's. Would you be inclined to sue me for defamation?
I own the Guthrie's.
Yeah, you own the Guthrie's. I've just told everybody that y'all sell cats and you call it chicken. Let's say that you do want to sue me. Have I committed libel or slander? Slander, because it's spoken. Let's see if you can meet the definition in court. Did I make a false statement of fact? Assuming what? Assuming you don't serve cat meat. Right. All right, so we've met that. Was it about your business and did it tend to harm your reputation? Yeah, I'd say so. Did I publish it to anybody besides just you? I did. Publication can be spoken. So in the legal sense, we think of publication as being like printed somewhere. In a legal sense, publication meant it was communicated out to somebody else. So I published that slander to the other members of the class. So he could sue me. Would you in practice, this is why I think you were thinking about it, Ethan, would you actually sue me for defamation in this case? Why might he not want to, Ryan? I don't have money to pay him back. Oh, if I didn't. What's he, okay, remember what we get at court in tort law, damages. What are his damages? Sales from the 25 of you in here. I mean, it's something, but is it worth you going to court and missing work and taking all your time and energy and hiring a lawyer to do? Maybe not. I'm not saying you wouldn't. If I say it to every class, every semester, then you might want to sue Tebow just to shut that down, right? But those are the decisions that you might make in tort law. Is it really worth it? I can walk up to you right now and take a swing and miss. I doubt you're going to sue me for assault because there's really nothing in it for you. You don't really have much damages. So I have met the definition, though, of defamation in that case. Yes, Kim. He said, she said. All right, so let's say that, so we go to court, right? Ethan's got to prove that I said that. What's his best proof that I said that? My video. That's pretty good proof. My next good proof is to call as witnesses. Mr. Janeway, do you swear to tell the truth, the whole truth, and nothing but the truth to help you God? When you were in class on the 28th of January, did you hear Professor Tebow talk about Guthrie's? Yes. What did he say? I heard him say they serve cat meat. That's pretty good evidence. I know you're thinking, as my lawyer, we're probably screwed in this case, right? I mean, what am I going to say? I didn't say that? Well, let's play the tape. So it could be he said, she said. If you had a he said, she said kind of situation, you'd probably be less likely to go to court because it'd be harder to prove. Let's say that Ethan and I are the only ones in the classroom. The doors are shut, and I tell him that Guthrie serves cat meat. No one else heard it. Is he going to have a problem with the tort of defamation? He is, because there's an element of defamation that he can't meet. That is the publication to somebody other than him. So we can trash talk people to their face as long as nobody else hears, and it's not defamation. There's another element that I want you to pay attention to in defamation. It's very important. What if I said, I ate at Guthrie's yesterday, and it was disgusting. Their chicken fingers taste like cat meat. You're my lawyer, Kim. Ethan sues us for defamation. Look at that definition for defamation. We got a great defense. The first element is a false statement of fact. What did I say? I said it tastes like cat meat. That's my opinion, right? That's not a false statement of fact. So it's okay to say bad things about others as long as you make it an opinion. That's because we have the right to freedom of speech under the Constitution. So even what if I said, that's a good question. I think that the statement, Guthrie's, those chicken fingers are cat meat. It'd be harder for me to say that's an opinion because of we're getting into semantics, right? But that is more of a statement of fact than it tastes like cat meat to me. All right. So another defense to defamation is truth. So in that first element, a false statement of fact, it has to be false. Ethan sues me for defamation. He's got to prove that what I said, not only does he have to prove that it was a statement of fact and not an opinion, but he's got to prove that it was false. Truth is always a defense to defamation. We can speak the truth out loud and in public to anybody about anything freely. All right. You do need to know that public figures have a little bit higher of a hurdle in defamation than private citizens do. Public figures have to prove the same things that private citizens do: the false statement of fact, the publication, and the harm. But they also have to prove actual malice, which means that the statement, that the person who said the defamation or wrote the defamation intended to cause harm by it. That's because public figures, by being public figures, put themselves out there in a way that they are not protected from some general trash talking that goes along with being famous, being public. Protects the press a little bit who cover public figures. makes it a little bit harder for them to prove defamation, to prove actual malice. There's a case that you're assigned to read for Thursday. I'm not, like, my teeth are getting ready to chatter. Is anybody else cold in here? The hell? Yeah. I'm not just getting old. Start wearing some little button-up sweaters or something. Public figures. The case for Thursday is brought by a former Major League Baseball player against another announcer who wrote something about him in his biography that he thought was defamatory. So you'll read that case and you'll notice as the court talks about that case, they talk about all the things that he's got to prove, but then they also include in there this analysis of whether or not he's got to show actual malice. There's also a defense to defamation that is pretty uncommon that you're going to see in this case for Thursday. And it's the defense of, remember, this is the person that's getting sued for defamation. The defense they use is, this person's reputation is so bad that nothing I could say can make it worse. That's the defense that the defendant uses in this case. So I do want you, that's the only thing you need to read for Thursday is, we're not done, but I want to just make sure I highlight to you that I do want you to read that case. For Thursday, we'll discuss it in class. I'll call on you to talk about it. All right, moving on from defamation. Invasion of privacy. You see this in a few different ways. One way that you see invasion of privacy is intrusion into an individual's private affairs or seclusion. That would be like hacking into my private social media accounts, hacking into my email, hacking into my phone and stealing my text messages or pictures, breaking into my house, going through my wallet without my permission, hacking into my laptop, intrusion into a place where I have a reasonable expectation of privacy. False light is a tort of invasion of privacy. False light is when we put somebody, usually happens with like publishing somebody's picture, but you have given the impression that somebody is doing something that is offensive or wrong when they're really not. Let's say that if I said that Moss's Guthries was serving cat meat, that's defamation. But let's say that I write an article about how some restaurants in Columbus serve meat that's not real, or some chicken finger restaurants have ingredients that are other than chickens. And I put a picture of the Guthries on Macon Road in my article, and I put a picture of a dead cat. I didn't say, the problem with defamation is I didn't actually say that Guthries serves cat meat, but I've implied it by including their picture. So he might not be able to meet the definition of defamation, but he might meet the definition of false light. I've placed his business or his person in a false light. Public disclosure of private facts. That's like, think about taking screenshots of private things that are texted or emailed, making those public. That would be a form of invasion of privacy. And then appropriation of identity. If you use somebody else's image in advertising without their permission for commercial gain, that's an invasion of privacy as well. So those are 4 different ways that you might see a tort of invasion of privacy. An important one in business context, an important intentional tort is fraud. So fraud would happen when these elements are met. There was a misrepresentation of a material fact. The intent was to deceive. The deceived party was justifiable in relying on it. And then there were damages as a result. So example I would use there is I sell my car on Facebook Marketplace. And Daquan messages me and says, I'd like to buy the car. Has it been involved in any accidents? I tell him that it has not been involved in any accidents when I know for a fact that it's been involved in 5 accidents. He buys the car from me in part based on my representation that it has never been wrecked. He finds out that it has, got all these problems with it, and he sues me for fraud. Kim, you're my lawyer. I'm calling you up all the time, your best customer. Because remember, I'm still paying you, even though we're losing these tort cases. You're still getting paid, although we've won a couple this morning. You're a really good lawyer. Did I make a misrepresentation of facts to Daquan? I did. Was it with the intent to get him to rely on it? Yeah, it probably was. Was it justifiable that he relied on it? I mean, yes, but can anybody make an argument that he wasn't justified? What if I'm like, it's Facebook Marketplace. You use Carfax. Who buys a car without looking up Carfax? You've got a responsibility to check that out for yourself. I don't think that's a winner. I don't think that's a winner at all. But it's a better argument than if I was a car dealership. And he's like, I'm absolutely justified in relying on you. This is what you do for a business. You sell cars. Your representation about whether or not they've been wrecked is, we expect that the dealership is going to be able to be truthful about that. Now, if I meet Daquan on the street corner and I'm like, hey, psst, you want to buy this car? And he's like, I don't know. Has it been wrecked? I'm like, no. I'll sell it to you for $200. Worth a lot more than that, obviously. He buys it from me. He sues me for fraud. Kim's got a better argument for me now that it wasn't justified in him relying on my representation about whether or not it was wrecked. Who buys a car on a street corner from a shady person for $200, right? Okay. Then we might make the argument that you weren't justified in relying on that. You knew what the risks you were taking in buying a car like that from some dude on a street corner. So again, always going to depend on the facts of the case. The torts are going to be defined in certain elements, and in order to recover under the tort in your trial, you got to be able to prove all the elements of the tort. Fraud is tricky in the commercial context because there is a certain amount of sales talk that really straddles the line between fact and opinion. Is this car reliable? Daquan asks me. Oh, it's reliable. What does that mean? Is that fraud or is that just sales talk? So you have to be really careful in that context, whether you're the buyer or the seller, about what you say or what you rely on. On Thursday, I have a lot more to say about some intentional torts, and then I'm going to have a lot to say about the unintentional tort of negligence, and then we're going to talk about that Dykstra case, which is the defamation case. So the only thing I need you to do for Thursday is read that case. Come to class Thursday prepared to talk about it. Remember, you do not have a quiz due this week. There's going to be one quiz for this unit, but it's not due till February 10th. We'll have class today, Thursday, next Tuesday, but not the following Thursday. Anybody, if y'all don't have any questions, then I'll see you Thursday. Yes, sir. The discussion question, I would wait until after we discuss negligence. You don't have to, but I would because that's the topic of it. But the discussion is not, it's just one for this unit.